In the United States of America, B.J. Fred Hart Jr., brought before the 8th Circuit in May 2000. The defendant, Mr. Hart, was identified as an attorney who practiced in Little Rock, Arkansas, and he was a self-declared anti-abortion activist who regularly engaged in peaceful protests outside abortion clinics. However, on September 24th, as recorded by the court, 1997, he rented 2 Ryder trucks in Little Rock under his own name. On September 25th, 1997, the same trucks were found in the driveways of 2 Little Rock abortion clinics, the Women's Community Health Center, and the Little Rock Family Planning Services, collectively referred to as clinics. The placement of the trucks at the clinics coincided with the visit from President Clinton to a Little Rock high school. Each truck was unattended and carried no indication as to its purpose for being there. Each truck was parked in the entrance driveway rather than an ordinary parking area. On the morning of September 25th, 1997, employees arriving at the clinics were alarmed by the presence of the trucks, reminded of the catastrophic 1995 bombing of a federal office building in Oklahoma City, Oklahoma, involving a Ryder truck. Employees of the clinics feared that the trucks contained bombs. They immediately left the buildings and notified the police. At each clinic, the area was evacuated and a bomb squad was called in to investigate. The authorities determined, however, that the trucks contained no explosive materials. The rental and placement of the Ryder trucks was tracked to Hart. A grand jury subsequently indicted him on 2 counts of violating the FACE Act. Hart filed a motion to dismiss his indictment, arguing that the mere parking of the trucks could not support a finding of actual intimidation and challenging the constitutionality of the FACE Act. The district court denied his motion. Hart then pleaded not guilty to both counts. Hart presented the testimony of Carrie Land, a special agent for the FBI. Through her testimony, Hart established that shortly after his indictment, he observed 4 Ryder trucks parked outside the offices of the FBI in Little Rock. Hart notified Ms. Land that Ryder trucks were parked outside her building, but she did not respond with alarm. In fact, she testified that she did not investigate the trucks until prompted by Hart's visit to the office, even though she had previously seen the trucks. She stated that she dismissed the presence of the Ryder trucks because she knew that other occupants of the building were in the process of moving. At the close of the government's case, Hart filed a motion for judgment of acquittal, again arguing that the government's case charged nothing more than the parking of a Ryder truck at each clinic, which, according to Hart, could not form the basis for a conviction. The district court denied the motion. On November 2nd, 1998, the jury returned a verdict of guilty on both counts. Hart was sentenced to 4 years of probation, the first 12 months of which he to be served in home detention, 200 hours of community service, and a special assessment of $50. Hart timely appealed. Nonetheless, the 8th Circuit affirmed the conviction, and under the FACE Act, codified under the Federal Criminal Code at 18 U.S.C. 248, A2, in addition to protections afforded to abortion facilities, this federal statute also provides that whoever, by force or threat of force, or by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to injure, intimidate, or interfere with any person lawfully exercising or seeking the exercise of the First Amendment right of religious freedom at a place of religious worship shall be subject to the penalties provided in subsection B and the civil remedies provided in subsection C. Beyond a reasonable doubt, the standard of proof that is required under the Constitution in a criminal prosecution, Virginia Governor Ralph Northam did, in fact, on March 15, 2020. at a time when there were only 3,000 cases of COVID-19 in the entire United States, interfere with a lawful right to seek the exercise of the First Amendment right of religious freedom in a place of worship, or a violation of the Free Exercise Clause. And on December 10th, 2020, Governor Northam did, in fact, concede, as reported by Charles Spiring, a reporter at Breitbart, that he could not legally limit in-person worship ceremonies, noting that the recent Supreme Court decision against the state of New York prevented him from doing that. And under the law, you do have a right to remain silent, because anything that you say or do can and will be held against you in a court of law. Under the FACE Act, a plaintiff in a civil complaint in federal court must also prove that the defendant had acted by force or threat of force or by physical obstruction, as in the case involving Mr. Hart in Oklahoma City. And at the time of his admission, reported by Breitbart in December 2020, almost immediately after the rollout of the Pfizer COVID-19 countermeasure products to hospital workers beginning in Norfolk, where he has a pediatric practice, Governor Northam, a medical doctor, did in fact continue to blame churches for contributing to the spread of the virus, noting that some houses of worship were not social distancing or wearing masks. I've heard reports they don't use distancing inside the church. They are not wearing masks. Quite frankly, we know that a lot of the spread is coming from this, he said. And in the courts, this conduct is described as occurring under color of law, intended to place in the mind of the hearer the imprimatur of official state action and determination. Under the FACE Act, codified at 18 U.S.C. Section 248C1A, any person aggrieved by reason of the conduct prohibited by subsection A may commence a civil action for the relief set forth in subparagraph B, except that such an action may be brought under subsection A2 only by a person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship, or by the entity that owns or operates such place of religious worship. To date, no place of worship in the Commonwealth of Virginia has proceeded against the former governor to allege a violation of the FACE Act or any detrimental reliance upon his word. But on April 13, 2022, we did file in the Federal District Court in Richmond a verified complaint that had included these allegations, amongst others. And on Maundy Thursday, the Christian holiday commemorating the Last Supper of the Christian Savior with his disciples, as recorded in the canonical Gospels, we did also file a motion for summary judgment on these claims. Under Federal Rule of Civil Procedure 56A, which provides that a party may move for summary judgment, identifying each claim or defense or the part of each claim or defense on which summary judgment is sought. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact that the movement is entitled to judgment as a matter of law. Moreover, under Federal Rule of Criminal Procedure 6A, when the public interest so requires, the court must order that one or more grand juries be summoned. On July 14, 2020, Jamie Ehrlich, a reporter at CNN, reported that Republican Representative Morgan Griffith of Virginia had tested positive for the coronavirus after developing symptoms, and that Griffith joined a list of members of Congress in both the House and the Senate, and in both parties who have tested positive for the virus. On January 2nd, 2021, Ganesh Sethi, a reporter at CNN, had reported that Virginia State Senator Ben Chapin Jr. had died after contracting COVID-19. According to a statement from his office, he was 60 years old. As a review of almost 56,000 laboratory-confirmed cases and properly their tracer contacts in China, employing 1,800 teams of at least 5 epidemiologists, it was determined that nowhere in China before the importation of COVID-19 to American shores was there found a secondary attack rate of more than 5%, which is 4 times too low to validate a disease that is being transmitted from person to person, and 12 times too low to set off a super spreader event, causing that joint mission sponsored by the World Health Organization on February 24, 2020, to conclude expressly, it is not clear whether this correlates with the presence of an infectious virus. And in October 2020, shortly before the infection of the former president, in the largest sample size tracer contact study to date on COVID-19, involving over 3 million laboratory confirmed cases in India, researchers validated this conclusion, again finding a secondary attack rate of only 4.6%, or in plain English, a disease that by the science possesses not the capability to be transmitted as a communicable disease. And it was not highly contagious, as former Virginia Governor Ralph Northam had falsely misrepresented in fraud. The nation's only physician to have served as a state governor during a once-in-a-lifetime pandemic had repeatedly alleged to the Virginia residents and the press, and that under the science could only be deployed as a biological weapon of terror. Under Cordova v. Hood, means of knowledge and the duty of using it are in equity the equivalent of knowledge itself. 18 U.S.C. Section 2332 Bravo creates a felony under the Federal Criminal Code for whoever involving conduct transcending national boundaries kills, commits an assault resulting in serious bodily injury, or assaults with a dangerous weapon any person within the United States in violation of the laws of any state or the United States shall be punished for killing, or if death results to any person from any other conduct prohibited by this section, by death or by imprisonment for any term of years or for life, for assault with a dangerous weapon, or assault resulting in serious bodily injury by imprisonment for not more than 30 years, or attempting or conspiring to commit an offense for any term of years up to the maximum punishment that would have applied had the offense been completed, and for threatening to commit an offense under this section by imprisonment for not more than 10 years. However, for purposes of convening a grand jury seeking an indictment and conviction for transnational conspiracy to commit terror, the jurisdictional bases for federal courts are restricted to limited circumstances to include that the offense obstructs, delays, or affects interstate or foreign commerce, or would have so obstructed, delayed, or affected interstate or foreign commerce if the offense had been consummated, and these deaths and infections were in fact used to continue to close places of worship and deny persons their freedom of religion. And if the victim or intended victim is the United States government, a member of the uniformed services, or any official officer, employee, or agent of the legislative, executive, or judicial branches, or of any department or agency of the United States. And the very first incident of infection in the Commonwealth of Virginia was on Fort Belvoir, a U.S. Marine who would be included in the jurisdictional basis under this provision. And, as noted, the member of the Congress who was infected was also an official inside the United States government, Representative Morgan Griffin, at a time when other Republican members of Congress were infected with COVID-19. Under this provision of the Federal Code, whoever threatens to commit an offense under paragraph 1 or attempts to or conspires to do so shall be punished. and jurisdiction shall exist over all principals and co-conspirators of an offense under this section and accessories after the fact to any offense under this section is applicable to at least one offender. Under this provision of the Federal Criminal Code, notwithstanding any other provision of law, the court shall not place on probation any person convicted of a violation of this section, nor shall the term of imprisonment imposed under this section run concurrently with any other term of imprisonment. In other words, all sentencing shall be consecutive and not concurrent. And the prosecution is not required to prove knowledge by any defendant of a jurisdictional base alleged in the indictment. Under this provision of the Federal Criminal Code, the term federal crime of terrorism means an offense that A, is calculated to influence or affect the conduct of government by intimidation or coercion, or to retaliate against government conduct, and B, is a violation of Section 175. Under 18 U.S.C. Section 175A, whoever knowingly develops, produces, stockpiles, transfers, acquires, retains, or possesses any biological agent, toxin, or delivery system for use as a weapon, or knowingly assists a foreign state or any organization to do so, or attempts, threatens, or conspires to do the same shall be fined under this title or imprisoned for life or any term of years or both. As reiterated in U.S. v. Elliott by the Fifth Circuit in 1978, direct evidence of agreement is unnecessary. Proof of such an agreement may rest upon inferences drawn from relevant and competent circumstantial evidence, ordinarily the acts and conduct of the alleged conspirators themselves, quoting from U.S. v. Morado, a Fifth Circuit case decided in 1972. Additionally, once the conspiracy has been established, the government need show only slight evidence that a particular person was a member of the conspiracy. Noted that court at that time. And of course, a party to conspiracy need not know the identity or even the number of his confederates, that court stated, quoting U.S. v. Andelchak, a case decided by the Second Circuit in 1944. As stated by the Fifth Circuit in U.S. v. Hurd in 2013, withdrawal is an affirmative defense, and the burden of proof is on the defendants or the accused. And a defendant is presumed to continue in his involvement in a conspiracy unless he makes a substantial affirmative showing of withdrawal, abandonment, or defeat of the conspiratorial purpose, as stated by the court in U.S. v. Mann, a Fifth Circuit case decided in 1998, quoting U.S. v. Fuegenfante, decided by the Fifth Circuit in 1994. In order to show withdrawal or disavowal, the defendant must show that he has committed affirmative acts inconsistent with the object of the conspiracy that are communicated in a manner reasonably calculated to reach conspirator. Under the decision by the Fifth Circuit in U.S. v. Hurd, quoting its prior decision in U.S. v. Mann. Moreover, according to the Fifth Circuit in U.S. v. Hurd, mere cessation of activity in furtherance of the conspiracy is not sufficient to show withdrawal or disavowal. Under Federal Rule of Criminal Procedure 6A, when the public interest so requires, the court must mandatorily order that one or more grand juries be summoned, a ministerial act before a federal court that is a proper application for a petition for writ of mandamus, and the failure of which pierces the veil of judicial immunity, so that even a federal judge failing to perform this mandatory duty and obligation can be held liable for both civil and criminal offenses. For, as the Supreme Court had stated in U.S. v. Nixon, reiterating the words of the former Chief Justice John Marshall in the historic case of Marbury v. Madison, it is the emphatic duty and province of the Judicial Department to say what the law is. And this briefing is unclassified. Yes, you were. My name is Major Mike Webb, and by God, I am running for U.S. Congress. This year resolved to do the right thing, and we shall make America great again. Honest. Carry on.
This advertisement was authorized by Mike Webb.